Good morning and welcome to Division 3 of the Colorado Court of Appeals. I'm guessing counsel for our first case did not realize what a crowd draw their case was going to be. So we do have two cases on our 9 a.m. docket. The first case is People v. Oliver, and I see that counsel is seated at counsel table and ready to proceed. Have you both had the opportunity to review the procedures? Do either of you have any questions? And is counsel here for our second case as well?
Yes, Your Honor.
Okay. All right. Very good. My name is Craig Welling, and with me today as part of Division 3 is Judge John Webb and Judge Elizabeth Harris. Our first case will have 15 minutes per side. One thing I'm going to ask everybody to do is please shut off your electronic devices. Not merely muting them, but please turn them off. Our proceedings today are being broadcast, live streamed over the internet, as well as archived on our website. And electronic devices can interfere with our recording equipment. With that in mind, I'd also remind counsel about the fact that these are being broadcast, so to the extent that there is any confidential or sensitive information, please be sensitive to the fact that these proceedings are being transmitted. And with that said, we are ready to call our first case, 15CA1722, People v. Oliver.
Good morning, and may it please the court. My name is Jeannie Siegel, registration number 50898, and I represent John Oliver. Mr. Oliver was denied his right to a jury trial. The jury was not aware that Mr. Oliver was charged with PAUPO. The jury was not instructed on PAUPO, and ultimately, the jury did not find Mr. Oliver guilty of PAUPO. The trial court directed the verdict in this case when it transformed a mere factual finding into a criminal conviction in violation of Mr. Oliver's right to a jury trial and his due process rights. This error cuts to the core of the American criminal justice system. I want to stress that this isn't merely a technical error. This isn't merely an error about an instruction or an error about a form. This is about the complete denial of the right to a jury trial on the PAUPO offense. The Fourth Circuit analyzed a very similar set of facts in Ramirez-Castillo when the jury was only asked factual questions about the disputed elements in the case and did not render an ultimate verdict on guilt or innocence. The Fourth Circuit analyzed U.S. Supreme Court precedent on the right to a jury trial and required reversal because Mr. Ramirez-Castillo was denied his right to a jury trial. It should be noted that the Attorney General makes no attempt to distinguish this case. And if anything, Mr. Oliver's case is even more extreme, because at least in Mr. Ramirez-Castillo's case, the jury knew that there was a criminal offense at stake. Here, possession of a weapon is not a crime. The jury was not aware that a criminal offense was at stake when it answered that factual question. A division of this court just recently in People v. Wambolt explained, a jury cannot convict on a charge on which it was not instructed. Here, the jury was not instructed on PAUPO. The jury wasn't even aware that the criminal offense of PAUPO was at issue. The jury could not and did not convict Mr. Oliver of PAUPO.
Is this structural or constitutional error?
Your Honor, this should be considered structural error. Sullivan v. Louisiana made it clear that error review is simply absent when there has been no jury verdict within the meaning of the Sixth Amendment. Rose v. Clark also made clear a trial court cannot direct a verdict no matter how overwhelming the evidence. The Colorado Supreme Court in both Sanchez and Medina applied structural error when the jury did not find the defendant guilty of the criminal offense at issue. In Medina, the jury convicted the defendant of a different criminal offense than the trial court. And again, this case is more extreme because here the jury did not convict Mr. Oliver of any offense. In fact, the only verdict rendered by the jury in this case was a not guilty verdict on a menacing charge.
Clearly, your client wanted this stipulation that led to where we find ourselves. Was a stipulation reached between counsel and the prosecutor, and your client benefited from it, right? I mean, the desire was to not only not disclose that he had a felony conviction, but also it avoided even disclosing the nature of that felony conviction, right?
Your Honor, the nature of the stipulation at the start of the trial was a stipulation to the prior offense, which happens frequently in PALPO cases and in other cases. It doesn't mean that the element is never disclosed to the jury. And in fact, courts across the country have found that in a PALPO case, that element cannot be removed entirely because to do so changes the nature of the offense. And so here, the removal of the prior offense meant that the jury did not know that there was a criminal offense at issue. And while defense counsel participated in that, the right to a jury trial is a right held personal by Mr. Oliver. He did not waive his right to a jury trial, and he did not receive a jury trial on the PALPO offense.
So if the parties wanted to actually proceed as they did, because everybody seemed to be on board with the way that you ended up proceeding, in fact, I think the defense wanted to remove even the weapons interrogatory from the menacing offense. So how would they have been able to? Would they have been able to just accomplish exactly what they did merely by having the defendant personally waive the right on the record, just like a Curtis advisement? And then could they have proceeded as they did?
Your Honor, under the facts of this case, Mr. Oliver never waived his right to a jury trial. The waiver has to be knowing, voluntary, and intelligent.
I'm giving you a hypothetical. Hypothetically, could they have cured this by doing that inquiry of Mr. Oliver, asking him personally, do you agree with the stipulation? Do you waive your right to having a jury determine this? Have you had a chance to talk to your lawyer? Do you understand that this is a personal right? Is anybody coercing you? I mean, could they have gone through that and had Mr. Oliver do it personally as opposed to through counsel?
Yes, I believe they could have. That isn't what happened in this case.
I understand.
Yes.
I understand that that's not what happened in this case, but is that the way to achieve everybody's end and not have a constitutional violation?
Yes. In a case like this where there is no jury trial, the only way to accomplish that is through a personal waiver from the defendant himself.
Okay.
Going back to this idea that this is structural error, under both Sanchez and Medina and U.S. Supreme Court precedent, structural error must apply and reversal is required. That being said, even under plain error review, a reversal is required here. There was an affirmative defense at issue in this case. There was a choice of evils defense. The defense presented evidence of it and argued it, and there is no real way for a jury to give meaning to an affirmative defense without knowing that a criminal offense is at issue. It simply doesn't make sense.
Well, but they were included within the definition of possession. That was kind of the carrying instruction for the interrogatory. The disproving the affirmative defense of choice of evils was an element that had to be proved beyond a reasonable doubt before the jury answered that question yes, right? I mean, it would have been in the same way that they would have answered it had, instead of yes, no at the bottom of that verdict form, it been guilty, not guilty, right?
However, I think the distinguishing factor here is that there was no knowledge of a criminal offense. And the way the affirmative defense was defined was Mr. Oliver's actions would be legally authorized if, and then the choice of evils instruction is given. Here, the jury had no way of knowing that it wouldn't have been legally authorized for Mr. Oliver to possess a weapon. The fact is, possession of a weapon in and of itself is not a criminal offense. And so, yes, that is correct. They were given that instruction. It just simply doesn't make sense. You know, an affirmative defense requires a corollary of a criminal offense. And here that didn't happen. So there was no way for the jury to really give meaning to it. And moreover, there are many facts that make this case unique. And one interesting fact about this case is that the only verdict rendered by the jury, as I mentioned, is a not guilty verdict. The jury acquitted on one menacing charge and hung on the other menacing charge. There's every reason to believe if they knew that a criminal offense was at issue on the PALPO charge, that they would not have convicted.
Does that matter to our analysis?
It depends if this court chooses to analyze this under structural error, which I believe is what should happen. In that case, reversal is required. Under a plain error analysis, I think it's a helpful fact for this court to consider.
Can I just ask a clarifying question? I mean, the question was, did he possess the gun, right? And there's instructions about what that means to possess the gun. And they said yes, based on the instructions and based on denying the affirmative defense. And you say, well, maybe that fact would have come out differently if they had known that an actual conviction was at issue. But why is that true?
Your Honor, the U.S. Supreme Court in United States versus Gaudin explained, the jury's ultimate responsibility is not merely to determine the facts, but to apply the law to those facts and draw the ultimate conclusion of guilt or innocence. And so the jury is not asked to merely make factual findings. The jury is asked to render an ultimate verdict on guilt or innocence, and that didn't happen in this case. So as I explained, I don't believe they could properly give effect to an affirmative defense without knowing there was a criminal offense. So I think that aspect of it was deprived from the jury. But also, it is the jury's responsibility to make that ultimate finding. And we're not asking for a mere factual finding. We're asking for a verdict on guilt or innocence.
What if the bottom of that verdict form had been guilty or not guilty of possession of a weapon?
Your Honor, possession of a weapon is not a criminal offense.
But the jury doesn't know that. They're being asked to determine whether or not he's guilty of what has been charged, and everybody wants to keep the fact from the way this is rolling out is it's in your client's interest to shield the jury from the fact of his prior conviction. So let's not forget that there is a strategic rationale for this. The only reason that it's illegal for him to possess a weapon is his prior felony, and the stipulation and the strategy of the defense is to avoid disclosing that to the jury while having them also make the ultimate determination as to whether or not he's committed a crime. So what if the bottom of that form had just said guilty, not guilty of unlawful possession of a weapon, and all they know is that all he had to do is meet these elements of possession?
Your Honor, the criminal offense at issue was paupo, and the jury needs to be aware of the criminal offense at issue in order to render a verdict on that issue. Regarding the strategy, I think McCoy versus Louisiana makes a helpful distinction, this is a U.S. Supreme Court case, where they distinguished between what the client's objectives are and the best way to achieve those objectives. And they found that the best way to achieve those objectives, that is a matter of strategy. That is something that defense counsel decides. But what client's objectives are the rights held personal to the defendant.
But McCoy has a salient distinction, and that is he voiced an objection to the admission to having killed his family. And he did it throughout. He made clear to the court, made clear to his lawyer that I am unwilling to admit this. And his lawyer went ahead and, in order to try and strategically reduce the likelihood of the imposition of the death penalty, went against his client's wishes. So that's not present here. The client was there for the stipulation, never voiced an objection. This is more akin to Nixon, which the McCoy court took great pains to not overrule in its decision last term, don't you think?
Your Honor, the defendant didn't need to object here because the only way for Mr. Oliver to give up his right to a jury trial is through a voluntary, intelligent, and knowing waiver. And because that did not happen, that is the client affirmatively taking the stance that he seeks a jury trial. He could have pled guilty if he wanted to. He could have sought a bench trial if he wanted to. He did not want that. He wanted a jury trial. And so this did go against his objectives. If there are no further questions, I'll reserve my remaining time for rebuttal. Thank you.
Thank you, counsel.
May it please the court. My name is Ellen Michaels-Neal, and I represent the people of the state of Colorado in this matter. My registration number is 43885. In defendant's reply brief and now in oral argument, he seems to have pivoted away from the argument that was in the opening brief. The argument that I'm hearing now is that this is a waivable issue, but he did not validly waive it. And unfortunately, the problem with that is that is a post-conviction claim, as is set forth in the Walker case that we've both cited.
Is there any dispute that there was, this isn't about the sufficiency of the waiver. Is there anything in the record to indicate that a waiver was sought? This isn't a matter like the cases that you cite where it's a collateral review issue as to whether or not the waiver was sufficient, right? Whether or not the advisement was enough. There's no indication in this record at all that the client waived it, is there?
Oh, there's a lot of evidence. And this is kind of why this is a post-conviction claim. Certainly the fact that he was present during all of the discussions of this is something that the court would consider in a post-conviction claim. The fact that he was advised about this during the Curtis advisement, he was advised that the stipulation had occurred, and he said, yes, I understand.
Well, he was advised that the stipulation had occurred in the course of telling him what would potentially be disclosed to the jury if he were to testify. Because his prior felony was a juvenile adjudication, if he testifies, it doesn't get revealed to the jury as impeachment, and then due to the stipulation, it doesn't come in because it's no longer relevant. So that was the course of that conversation, but there was no discussion with him about waiving his right to have a jury determine his guilt on POWPO, was there?
Yeah, there was. In the Curtis
Where?
it was also in the Curtis advisement, and I think I cited it in my answer brief, which is over on my desk. But if I recall correctly, would you like me to go get it?
No, that's okay. But,
Okay.
you're saying that it's in the Curtis advisement?
It is. It's all part of the Curtis advisement where they discuss. So the court says, there is a stipulation, as I understand it, Mr.
Where are you?
Oliver.
What page are you on?
I'm on page 9 of my answer brief.
Oh, okay.
And that would be trial transcript, April 29th, 2015, pages 12 to 13.
So that's not the Curtis advisement, is it?
I think it is.
No, I think Curtis advisement is in like around 120. But go ahead.
Wait. So he says, the court says, there is a stipulation, as I understand it, Mr. Oliver, that you did in fact sustain the adjudication, and should the jury find that you possessed a weapon and that you were justified in doing so, then that can be used. I mean, that stipulation will come into effect with respect to the other possession of a weapon count. Is that clear, sir? Yes. So he did understand this, and he didn't ask any questions, and he didn't suggest that he had any issue with the
What
stipulation.
page of the transcript is that? I just want to make sure.
12. It was April 29th. Pages 12 and 13 is the site that I have. I don't have a line number.
I don't have any response by Mr. Oliver. I do have by Mr. Gardner.
I have the defendant says
Okay.
yes.
All right, I'll take a look. Thank you.
Okay. So he was present for all of this, and he knew about everything that was going on, and he never voiced an opinion. And this is where, as you pointed out, this is closer to a Nixon case as opposed to a McCoy case. But frankly, I don't even think we get to this, because what we're discussing is, was there an error? And what we need to talk about first is, did he waive that? And this is a very clear case of waiver. Everything that was done in this case was done for the defendant's benefit. He was present, he understood what was going on, and his counsel explicitly agreed and participated. So this is actually a combination of waiver and invited error. Certainly, the stipulation would never have occurred had he not agreed to it.
Well, are you distinguishing between conduct of his counsel as a matter of waiver or invited error versus what I think Judge Welling was asking, which is specific affirmative waiver by the defendant, regardless of what his counsel may have been trying to do?
Well, I'm lumping it together because normally counsel can operate for the benefit of the defendant.
But isn't the defendant's right to a jury an exception to that general power of counsel?
Yes, that is correct. However, I would disagree that this is a right to a jury trial issue. I think this has more to do with jury instructions, which we know is within the power of defense counsel, and the right to stipulate to evidence and operate with how evidence comes forward, which is also a right to counsel.
Is it your position that that Wambold is distinguishable, or we should just not follow it?
I don't think Wambold really applies
Why
in this
not?
case. I just, when I read it, I did not think it was factually similar at all. It was addressing a completely different set of circumstances. This is a stipulation that it's involved here.
Well, doesn't Wambold teach us that for the jury to return a verdict within the meaning of the Sixth Amendment, the jury has to be told that a particular charge is on the table?
That's generally the case,
Or was
except...
the jury told Pawpaw was on the table in this case?
No, it wasn't, because the defendant specifically asked that it not be.
Well, do you say the defendant?
The
which is-
defense counsel with the defendant present while that happened. Now, if you feel that this is something that the defendant had to personally participate in, that is an issue that should have been raised in the opening brief, and that's a claim that really is not properly before this court. It is a post-conviction claim, and that needs, there's nothing in the record to indicate that he did not want this stipulation or the instructions the way they were. So if this is something the court would like to see a record on, it has to be in post-conviction, as Walker sets forth.
But doesn't there have to be an affirmative waiver of the right to jury trial? And so what are we going to see later about the affirmative waiver of a right to jury trial on the record?
Well, I cited the Davis case, which came out fairly recently, and that had to do with the waiver of the right to testify, I believe, which is very similar to the right to a jury trial. They've been analyzed similarly in the past. And in that case, the defendant was advised about the right to testify, but he didn't actually affirmatively waive on the record. This was in post-conviction, mind you, that this was addressed, and so there was actually a better record for it. But that court found that there was nothing to indicate that the defendant had not waived that right, even though it wasn't specifically on the record.
But the posture of that case is very important because it is post-conviction.
Right.
And there was the Curtis colloquy that they went through about, do you understand your right? It's your right, it's your personal right. The lawyer can't make you decide it. And where it sort of veered off was the prosecution asking the judge, will you now ask the defendant whether or not he wants to testify? And the judge says, it's none of my business. And then in post-conviction, the defendant says, I was coerced into testifying, and I will present evidence to that effect in post-conviction. Get to post-conviction, 28 years later, the lawyer has no specific recollection of this conversation, but says, even if I didn't want him to testify, I would have been very direct in that, but I would have never stopped him from testifying. And then the defendant does not come forward with any other evidence. The evidence that was promised in the motion doesn't come forward. So that becomes really a sufficiency of whether or not the waiver was valid and how it was made. Here, there's simply nothing in the record that there was this sort of colloquy with the defendant that he was waiving his right to have a jury determination of paupo. Counsel certainly did it throughout, but nothing from the client on that. So why would this be post-conviction as opposed to on direct review?
Because there's just no record, and it's the defendant's burden to show that he didn't. This is more like a Nixon case, I guess, would be where I'm going with this. In Nixon, there was a lot of testimony from defense counsel saying, I advised him about this. I advised him that I was basically pleading him guilty to a lesser. He didn't respond, and so that's what we have. There wasn't, to my recollection, in that Nixon case, which was cited in McCoy, there wasn't an on-the-record discussion of that, and that is a much more severe situation because what we have going on there is actually pleading someone guilty without an advisement.
Well, it's not pleading them guilty. It's admitting to the factual basis for the jury to make the guilty finding. And there, the jury still has to make the finding. I mean, what it is counsel making the strategic decision to sort of concede some elements of the offense in order to potentially get mercy of in some way or another. But still, the jury still makes the factual determination that the burden has been carried. Here, the jury never makes that. That is taken out of the hands of the jury and put into the court's hands.
Well, by stipulation.
By stipulation between counsel. If we disagree with you that this is something that counsel could do versus a personal right of the defendant, How does that change your argument? Can you still prevail?
Yes, because I think, again, first of all, it's a post-conviction claim. I don't see how, without some sort of evidence to suggest that he didn't want it, when everything in the record shows that he was present for this. And we have U.S. Supreme Court case talking about what a waiver looks like and when to consider a waiver. And the point of all these cases is that we do not do form over substance. And so what
You
we,
mentioned a Supreme Court case, is that Nixon?
yes, yes, and that was cited in McCoy. I think it was basically there was a line that McCoy was trying to parse out, where on one hand, no, you cannot plead someone guilty against their own stated wishes, and on the other hand, what you have is if they don't say anything, then it's fine.
Well, even if we accept your reading of Nixon, how is the record in a post-conviction proceeding going to tell us or going to inform us about something that isn't in the record before us? I mean, we know what everybody did. We know when the defendant was present. We know what he said. We know what he didn't say. Why isn't that the end of the story?
Because this is frankly kind of an ineffective assistance almost claim. And so what you would want is defense counsel to then come and testify about what he did and did not talk about with his client. Did I talk about this stipulation? Did I talk about how harmful it would be for the jury to find out that you were convicted or adjudicated for sex assault on a child? Did he agree with me that this was the right way of doing this?
Well,
This-
doesn't the ineffective assistance claim arise only if and after we were to rule for the state in this case? In other words, if we rule for the state in this case, then he may have an ineffective assistance claim that would implicate all the inquiries you suggest. But how are those inquiries determinative of what occurred in his presence and what came out of his mouth?
And I think what we're getting at is more of a form over substance, and certainly whether a defendant has waived a right, I think, is kind of a plain error standard of review if it hasn't been raised below the validity of a waiver. And he was advised, he had some advisement of what happened. He was physically present. He didn't, there's nothing to suggest that he made any faces or anything like that. Certainly the facial expressions of a defendant as he's listening to a stipulation is something that a trial court would be able to look at and say, oh, wait, he looks like he's not happy with this stipulation.
Well, that'd be in the record of the trial, not the record of the post-conviction.
Well, it's something that could come up, like a Batson hearing. Like they come back later, they say, I did not see anything like this that would suggest anything other than this was a stipulation agreed to by everyone. We do know that he was at least somewhat advised of it, and frankly, there is no form advisement about how to do this, because this is a stipulation that was done for his benefit.
Isn't there a form advisement on waiving the right to a jury?
Yeah, but this isn't really he had a jury trial. He just didn't have a jury trial as to one element. And so if you look at what the form advisement is for waiving a jury trial, it talks about it just talks about a lot of stuff that is not what happened here. And if you were to advise a defendant about that in a situation like this, it would be incredibly confusing and wrong.
Let me ask you a hypothetical. Let's say that this had proceeded to a bench trial, and the way that it ended up at just a full bench trial was counsel came in and said, my client's decided he'd rather have a bench trial. I've talked to the prosecution about it. We're in agreement. So we're just going to try this to the court. My client understands this. Court says, okay, I accept it. We're going to go to a bench trial. Would that be reviewable and client was there for that waiver? What would the outcome of that be? Is that reviewable on direct appeal, and would it survive?
It would be, if anything, it would be reviewable under plain error.
Why not structural?
Huh?
Why not structural?
Because whether or not someone waived a right is, and I actually have case law on this. The problem I have is that this was an issue that wasn't really raised until the reply brief, so I haven't been able to offer some of this case law. There's the United States v. Vaughn, which talks about whether a valid waiver has occurred or not is a question of plain error.
Okay. Very good. Thank you, counsel.
And if the court would like me to submit supplemental briefing as to this new claim, I'd be happy to do so.
All right, we'll discuss that among the panel, and an order will issue if we desire that. Ms. Siegel, you have a little bit over 3 minutes remaining.
Thank you, Your Honor. A waiver of the right to a jury trial, which is one of the select few rights held personal by the defendant, requires a knowing, voluntary, and intelligent waiver. That did not happen here. There is nothing in the record to indicate that that happened here. And there is no need for a further record to be made because this record is clear there was no waiver of this right. The Attorney General points us to the Curtis advisement. There at no point does Mr. Oliver waive his right to the jury trial on the Paupo offense.
So is it your position that no matter what occurred in his presence, and no matter that he, as Judge Welling pursued in a prior question, I mean, he clearly benefited from keeping the child sexual assault evidence out of the jury's view. None of that matters unless out of his mouth he says, yes, Your Honor, I waive my right to a jury.
He needs to make a knowing, voluntary, intelligent waiver of his right to a jury trial. Not to mention, he could stipulate to that prior offense. That happens all the time, where the jury doesn't find out the name and the nature of the prior offense. The jury just finds out the parties have stipulated to the prior offense. You may regard that as proven.
In entering that stipulation, is the consent of the defendant on the record required? Is that personal?
No, Your Honor. Defendant doesn't need to personally be involved with every stipulation to an element. The problem with what happened here is that the entire criminal offense was no longer at issue in this trial. In a Paupo case, without the prior offense element ever coming into play, this jury wasn't aware that Mr. Oliver was charged with Paupo. Moreover, this jury didn't render a guilty verdict on Paupo. So with something like that, we're talking about this broad right to a jury trial. And in that sort of a case, the defendant needs to waive his right to a jury trial. Defendants can stipulate to elements and certainly do all the time. The problem here is that the entire criminal offense was removed. And this is a unique set of facts. Normally during voir dire, the jury is told that there's a criminal offense at issue. Normally,
They actually wouldn't have been told that during this voir dire because it would have been bifurcated. So they wouldn't have, I'm just going to remind everybody, please make sure that your cell phones are, I'll give you stop time. Please make sure that your cell phones are off so that counsel's argument as well as our recording equipment is not interrupted. I appreciate that. Sorry about that, counsel. Remind me where we were.
bifurcation.
Okay, bifurcation. So voir dire, they wouldn't have learned about this during voir dire because the point of bifurcation is to allow them to decide the menacing charges without knowing about the prior felony, right?
That is correct. In this particular case, it looked as though it would proceed to bifurcation, and so they weren't told here. I'm saying generally there are multiple times where the jury is informed of the criminal offense at issue. That never once happened in this case. This is about the complete denial of the right to a jury trial. And while aspects of this case may seem complicated, the simple fact is that Mr. Oliver's jury did not find him guilty of a crime. This conviction cannot stand, and I would ask this court to reverse and remand for a new trial. Thank you.
Very good. Thank you, counsel. We appreciate your arguments today as well as your briefing in this matter. We'll address whether or not we'll be requesting supplemental briefing. In the meantime, the case will stand as submitted and a written order will enter in due course. We'll now ask the attorneys for the next case. Yes? Certainly. Let's go ahead and we'll take 5 minutes while counsel for our next case gets set up. So we'll stand in recess. Good morning, everybody. This is still Division 3, and we're back for our second case on our 9 a.m. docket, Larry versus Silla Vista Ranch. I see counsel is present. Did you have something you needed to address?
Yes, Your Honor.
Okay.
I did, and plaintiff's counsel may have the same issue to address. We have blown up a map from the record that we'd like to refer to during our argument. I believe plaintiff's counsel, appellee's counsel, has done the same thing.
Okay.
And before we get started, I just wanted to ask the court's permission to put that up and refer to it at times during the argument.
Very good.
Do you have letter-size copies of that we could actually have on the bench with us?
I have one copy with me.
Well, it's probably more important that you keep that.
Actually, I do not need it, so.
Do you want to
I'm happy to
approach?
give one copy.
Please approach.
I probably have the worst eyesight of the bench, so.
And if you'd provide the same from,
And it's in the record at 12746.
Okay. And we also have a couple of unusual things about today's case. The court, by its own, on its own motion, ordered expanded oral arguments for a half hour per side. We also have an appeal and a cross appeal. However, the issues are sufficiently related that the way that we're going to do this is the appellants will go first, address issues on your appeal as well as issues on cross appeal. The appellees will have an opportunity to respond, but we're not going to allow any reservation of rebuttal time. It'll just be like a regular argument as far as you use up your full time and then whatever's left you can use for rebuttal. Is that acceptable to everybody?
Yes, Your Honor.
Okay. And also, it's up to counsel to figure out how you're dividing argument among counsel, and I leave that to you. So are there any questions about the procedures?
None from plaintiffs, Your Honor. None, Your Honor.
All right, so we're ready to begin.
Good morning, may it please the court. My name is Ronald Fano, my bar registration number is 20797. I'm here on behalf of the appellant, Silla Vista Ranch 1, LLC. With me at counsel table is Mr. Patrick Tooley. He is here on behalf of the appellant, Horoso Creek Ranch, LLC, and Western Property Investors, LLC. Mr. Tooley has conceded all of his time to me, so I'll be the only counsel for the appellant that you'll be hearing from today. Over 15 years ago, the Colorado Supreme Court issued two opinions in this long-standing case that remanded the case back to the trial court to do two things: adjudicate claims of landowners to profits of prendre on the former Taylor Ranch, now known as the Silla Vista Ranch, and to enter all necessary orders to safeguard those rights. I entered my appearance in the case in August of 2004, and while I had a suspicion that we'd be back on appeal one day, I had no idea that it would take 14 years to get here. Be that as it may, we are here because we believe the trial court made multiple errors in the remand process, with such errors resulting in nearly 5,000 people owning over 6,000 different parcels being granted unregulated rights to take and use the natural resources of the privately owned ranch. I have to say at the outset, our appeal is not in any way, shape, or form a challenge to the Supreme Court's decisions in Lobato 1 or Lobato 2. It is a challenge to the trial court's misapplication of those decisions, its failure to follow those decisions, and the underlying law. Now, we've raised multiple issues in our briefs, but really we can group our issues into two main categories. First, process errors regarding the manner in which the rights were granted, and secondly, use regulation errors regarding the manner in which the rights were allowed to be exercised. I'm of course happy to take up any issue that the court wants to hear about. I'm going to start with the process errors. This case always has been a Rule 105 quiet title action. With that, of course, goes a corresponding burden on the plaintiffs to prove the title that they are trying to quiet, and a corresponding right of the defendant to have a chance to confront the evidence that's being presented on the title that is trying to be quieted, with the end goal being, of course, finality, a conclusive order as to who has title to what and achieve that finality. There is nothing in the Supreme Court opinions in Lobato 1 or Lobato 2 that excused the trial court from following Rule 105 or the standard process whereby people become parties to a case, they make claims, the defendants are able to confront those claims and those people, and the evidence. And yet the trial court on remand stated that it believed that it was excused from following Rule 105 and that claims and adjudication process because it was charged with the task of avoiding protracted litigation. That was absolutely not the case. That does not appear in the Lobato 1 or the Lobato 2 decision. Rather, quite to the contrary, if you read Lobato 2 closely, Lobato 2, the Supreme Court says in multiple places that it is looking on remand for a process where individual landowners make claims, establish their rights, and meet a requisite burden of proof. That's what the Supreme Court wanted and stated in Lobato 2. That was not done by the trial court, and that was an error. Instead, what the trial court did is it instituted two processes, and I'll get to both. But the first process is it took Map A, Book E from the Costilla County records. And the property from Map A, Book E is shown on the dark lines on our map. And I apologize that this is not in color, but it wasn't in color in the record, and I wanted to observe the request of plaintiff's counsel that I not alter the map. But if it helps at all to highlight any of this, I'm certainly happy to do so. But what the trial court did is it said, okay, with respect to Map A, Book E, the Supreme Court said that Map A, Book E appears to be the best evidence of settlement. And so what we're going to do is we're going to just have an administrative process with a court-appointed title company who's going to come in and they're going to say who owns property on former Map A, Book E property, and then we're just going to grant those people rights.
Mr. Fano, did that result in some property owners who should have been excluded? Did it result in them getting access rights?
Well, we don't know, and that's part of the problem, because what we don't know is we don't know, no one was made a party to the case. So we don't know if anybody who appeared on the reports of the title company, and that's how it worked, the title company would issue reports with hundreds of names of people purportedly owning property on these bar strips, and then those people were just granted the rights. So we don't know, and the second piece of this is that the court was very protective of the title company. And so we did not have the opportunity to put the title company under oath and examine them to determine how they decided that Map A, Book E was indeed evidence of settlement, because the Supreme Court just said that it appeared to be.
The title company's job wasn't to decide whether or not the Map A, Book E property was settled in the time of Gilpin. It was to connect what is in Map A, Book E to current ownership, and not to answer the threshold question of does Map A, Book E represent lands that were settled in the time of Gilpin. That was not part of their charge, was it?
If it was not part of their charge, it should have been, or someone needed to present evidence that Map A, Book E was settled, that property was indeed settled by 1869.
Why didn't the stipulation take care of that? It was stipulated that going to the stipulation, is the appendix to that stipulation coterminous with, or the exhibit, the map exhibit, is that the Map A, Book E property?
I believe the Map A, Book E property is included on that map.
Okay.
Okay.
And so the parties stipulated that what is shown in Map A, Book E was settled in the time of Gilpin, right?
If that stipulation does apply to the Map A, Book E process, and we believe that it does not, for a variety of reasons, but if that stipulation does apply to Map A, Book E, then yes, then the issue of settlement would have been stipulated too. But what was not stipulated to in that is the fact of whether people needed to be made parties or not, and in fact, the plaintiffs stipulated in paragraph 7 of that stipulation that a claims process needed to take place. So if Map A, Book E is part of that stipulation, then they agree with my argument here today that part of the Map A, Book E process needed to be individual claims and not an administrative process.
But I want to separate who owns what today from the question of what was settled in the time of Gilpin. In other words, what property has these rights versus who are the current owners that can exercise those rights. And you seem to be kind of conflating the two and calling into question the process around both of them. But is there really a challenge, given the stipulation, to, at least with respect to the Map A Book E, that it was stipulated that Map A Book E was settled in the time of Gilpin, and now our task with respect to that is just determine who owns it now?
I will not run away from the fact that that stipulation and that map, whatever property is included on there was evidence presented that that property was settled.
Well, no, that's also the beauty of the stipulation. It alleviates the parties from needing to present evidence. Once the parties agree to it, you don't have to present evidence in support of it. It can be just a conceded fact. So why do the alleged process errors go to determination of whether or not the Map A Book E properties were settled?
Well, if we agree that that stipulation applies to Map A Book E, then you're absolutely right, and we do not have an issue with respect to proof of settlement. But
Then tell me why it doesn't. What's your argument that it doesn't?
because it was clearly set up in 2015, it was clearly set up in terms of the southern half process. I don't believe that my opposing counsel would have stipulated that a claims process was necessary for property shown on that map if that stipulation was intended to apply to the Map A Book E process.
Didn't both sides just reserve the right to request a claims process? I mean, that was sort of in the reservation as opposed to a stipulation that a claims process was required, isn't it?
No, paragraph 7 of that stipulation
Okay.
was a flat-out statement
Okay.
about claims being made. But if we assume that Map A Book E was settled, that still doesn't solve the procedural problem, because we still don't have anybody who was made a party to the case from the Map A Book E process. No one was made a party. There's been no proof as to whether somebody owns property that's on one of those VARA strips, and this title company, we were told, was not certifying title. So we don't have anybody who has made a party, we don't have anybody who made a claim, and we haven't been able to confront anybody as to whether those two other pieces apply, whether there's an overlap and whether there is proof of ownership.
Judge Webb?
Well, I'm not sure what you mean by confront people. What property ownership is a matter of public record. So if the title company comes in and says, John Webb owns a lot within the Map Book A, Map E area, what are you going to confront me about?
Well, there is the first of all, the title company wasn't certifying title, and we weren't able to see a lot of their work product as to how the property lined up.
Well,
So-
they were not certifying a chain of title, and the Supreme Court said that wasn't necessary. Wasn't the title company informing the trial court of present ownership, which implicates title?
That's what they were purporting to do, but they were not. The trial court's charge to the title company was not, you are not certifying a chain of title. It was, you are not certifying title. In fact, the trial court talked in terms of, after the process was done, going back and finding out who was now the current owner because the process was taking so long. And if the title company comes in and says, Judge Webb, you own X piece of property, what we don't know, because we weren't allowed to confront the title company, is we don't know if Your Honor's property is indeed matched up with a Map A, Book E, VARA strip parcel.
Isn't that what the title company is telling the court?
That's what they were telling the court, but we never had the opportunity to confront them. In fact,
Well, okay, I think that's a little different question. My question is, what are you going to confront me about if the title company has already said my lot's within the boundaries of Map A, Book E?
well, potentially, have you ever waived your rights that are being subject to the adjudication? That would be one question in terms of individual property owners.
Was that ever raised below? There's a question of waiver? There would probably be an affirmative defense.
Well, we weren't allowed to present any affirmative defense except for res judicata on appeal, on the remand. And without claimants and without people being parties, we had no claims within which to respond to.
But that goes back to the scope of the mandate. The Supreme Court said, go back, figure out who owns it, and the one thing that they're or who's the current owner of timely settled lands, and they are subject to one affirmative defense, and that is res judicata. And with respect to res judicata, whether or not they were named and served. So this notion that you're going to confront a potential owner about waiver or other affirmative defenses, that's not material at this phase, is it?
Well,
I mean, what were you deprived of?
Well, I think we were deprived of the opportunity to have claimants in front of us that we could indeed confront.
For what purpose, given the scope of the mandate?
For the purpose of them meeting their burden of proof. We do not believe that the burden of proof was ever met. And then also, the importance of bringing parties in is to achieve finality. As the fact that we don't have parties to this case means that no one is bound by anything that happened. You see, what the trial court did when it got the case back is it determined that the footnote that was dropped in Lobato 2 about the court should reconsider class certification, the trial court decided that the Supreme Court had already determined that a class needed to be certified and that all the elements of class certification had been met. Absolutely not true. The court needed to engage in a process under Rule 23 in order to effectively certify a class, and it didn't do that.
Mr. Fano, I'm sorry to interrupt you. I
No.
just wanted to go back before we get to the finality issue. It just seems to me that you're still not totally explaining why the so-called process errors really matter. What's the upshot? I mean, what happened as a result of the process errors? You say they didn't prove that that they had the access rights? Who doesn't have the access rights?
The process errors go to, first, due process and the making of people parties, so of course we can achieve finality. That's first. Secondly, keeping in line with the mandate from Lobato 2 and the requirement that individuals make claims and meet a burden of proof. If someone is not made a party, they cannot take advantage of any evidence that's presented in the case. And so there's this notion of, well, does it matter? Well, it certainly matters to make people parties for due process and for finality. And if they're going to take advantage of the evidence that was presented, and we don't believe that the evidence presented was sufficient to reach the conclusions that the trial court did because we didn't get a chance to confront the evidence of the title company, then we have nobody who's been made a party, we have nobody who's been made bound, and we have no quiet title. So there's a process that needs to be followed in order to make people subject to not only the benefits of this case, but the limitations of this case. And then it goes to notice. No one was given notice that their rights were being adjudicated. And that could have a significant impact. The Supreme Court said in Lobato 2 that individual landowners needed to be identified and notified. Rule 23 provides for notification, due process. The case of Mountain States Telephone and Telegraph versus District Court tells us for due process to apply in class actions, you need to give people notice. No one had notice. So if someone, whether they own a Map A, Book E property or another property, if they didn't want to be part of this case, if they don't want to be subject to its restrictions, they should have had the opportunity to decide that in order to fulfill due process. Due process was not served here because the court went to its administrative process and didn't make anybody subject to the case, as we continued to ask for.
In your view, is this an opt-in or an opt-out class as to the Map A, Book E parcels?
Well, I think what first had to happen is a Rule 23A analysis had to be done as to whether there should be a class at all. And there are significant questions as to whether there should have been a class at all, but no hearing was held. No determination was made. So, for example, was joinder impracticable? Well, we heard from Lobato 2 what they thought of the Torrens action and what Jack Taylor did or didn't do. At the start of the remand, the then ranch owner, before I became involved, filed a motion with a plan to serve everyone in the county. So joinder may not have been impracticable. Secondly, were the class claims typical of everyone involved? Well, maybe, but we heard in the briefing in this case that the 100 original plaintiffs, they chose the property closest to theirs, in the closest proximity to theirs, that being the ranch, being east of the lower part of the Vara strips. They chose that because it was closest to their property. Well, the other 4,900 people who have been granted access rights, they don't have the same proximity, so maybe the claims aren't typical. Was the representation adequate, class representation adequate? Well, again, we're dealing with limited resources of a ranch that, while it's large, its resources are not unlimited. That ranch, we submitted evidence that showed that the ranch was 15% of the entire original dominant estate. The 100 original plaintiffs chose that as their target. Well, everybody else may not want to share the resources of 15% of the dominant estate. So first off, a Rule 23A analysis needed to be done. And then if a class was certified, then the court needed to decide either opt-in or opt-out. And the southern half process that was done after the MAP A Book B process, that was done as an opt-in process, and I believe that that process was done properly. So the answer to your question, Your Honor, is if a class was going to be certified following a proper 23A hearing, that it should have been an opt-in process.
And when I say you, I recognize there were prior counsel involved. Did the ranch owner ever move the trial court to hold a 23A hearing?
Yes, the original motions filed upon remand there was a motion for class certification, there was a challenge to that, and no hearing was held. It was just ordered on the motions. So no 23A was held. And then when we were involved, we filed a motion asking for a hearing as to whether subclasses, at least, should be certified. All denied, all without a hearing. And nothing that we requested a hearing for was ever granted. And I want to touch on the southern half process, and then I'd like to get to the use regulation errors while hopefully reserving a little bit of time. The southern half process, what happened is the trial judge decided that I applied this presumption with respect to MAP A, Book E, and I didn't require anybody to come in and make claims. But for the southern half process, I'm not going to apply that presumption. And what I'm going to do, and in our opinion correctly, is follow Lobato 2, and I'm going to have the identification done of everybody in the southern half, and then I'm going to send them notice, and that notice is going to tell people that they have a right to be a part of this case. And if they don't want to be a part of this case, they don't have to be. But if they do, they need to turn in a form. And if they turn in a form, they're going to have a hearing. And at that hearing, they're going to have to present evidence, and they're going to have to meet a burden of proof. That was a proper process, and it worked.
But the evidence that they had to present went to whether or not their land was timely settled, right?
It went to all three factors. It went to whether their land was timely settled, whether they owned property within land that was timely settled. So, for example,
You said three. I got two.
I'm sorry. Yes, there has to be the overlap. So the property has to be settled. There has to be an overlap of the property being reported on. I'm conflating MAP A, Book E. But they had to prove that they owned a parcel within what was settled, that they owned it, and that was the burden of proof. So it worked in two different ways. If you look at page 31 of the answer or an opening brief of the appellees, there's an example. There was an individual, he didn't have a lawyer, he came in, he made a claim. He presented his evidence. We confronted that evidence. We had a hearing. The court determined that he did not meet his burden of proof of showing that his property was settled. His claims were denied.
Because that's really where the rubber's going to meet the road with respect to the second process, is the big question of which of the lands were settled and what wasn't. That part is taken care of by a stipulation with respect to MAP A, Book E. It's timely settled. And now the only thing that has to happen in that first process is who owns it. We have the title company report. And going back to Judge Harris's question of, was there anybody that was identified as owning MAP A, Book E property who didn't? I mean, so the reason that the processes were different is the issues were different. Now it becomes an individualized determination of timely settlement, an issue that was taken off the table by the party settlement or stipulation in the first part. So I see a pretty strong justification for procedurally approaching these differently in the opt-in versus opt-out versus opt-in processes.
And the dispute I would take with that, Your Honor, is that stipulation wasn't designed for MAP A, Book E. But even if it is, We still don't know, we don't have the evidence presented as to whether the overlap was done appropriately. In the record, page 9510 and 9511, we raised an objection, and we raised numerous objections through the course of time, to a report of the title company. Because the title company said in their report that they found some tracts of land and they appeared to have 1913 tract numbers. There was no ability, there was no effort made to link that up to a Map A Book E property, and we raised that objection. We needed to be able to ask the title company about how do you get from something that doesn't have a Map A Book E number and it appears to have a 1913 number, how is it that you conclude that it's on Map A Book E? We were denied the ability to ask them how they reached that conclusion. So I don't accept the fact that everything that the title company reported on showed the necessary overlap. Then back on the southern half process, where we end up disagreeing is that because of that stipulation, which again, we believe applies only to the southern half, but with respect to that stipulation, what happened not with individuals like the gentleman in page 31 of their brief, but some of the geographic areas of Map A Book E, they had counsel. And what they did is they presented evidence to me as counsel for the ranch owner, which showed that there was evidence that certain geographic areas were indeed settled. And we accepted that to avoid the time and cost of litigation. The evidence seemed sufficient to us. And then what we required is those people who had been told, if you want to make a claim in this case, come in and make a claim, those people who did so, they would sign affidavits and marking on the map where their property was located. They were swearing that their property was within the settled area. If they did that, that was sufficient, and we entered stipulations as to the access rights. Where we disagree on the southern half process is that the plaintiff's counsel wants to now go back and institute another leg to this and say, what we really should do now is, now that we've got a stipulation as to settled areas, we really should have the ranch owner pay to find out everybody who owns property in these geographic areas that there's been stipulations as to settlement, and grant them the access rights, even though they were given notice telling them they can opt in if they want to opt in, or they can opt out. So what we'd be doing is we'd be adjudicating, at the ranch owner's expense, we'd be adjudicating rights to people who expressly decided not to be parties to the case. We think that is improper. That is what they are asking for in their cross appeal. We think the southern half process was done absolutely correctly and that it should remain. I'd like to touch briefly on the use regulation issues. It pertains to the court's failure to give us a hearing on crucial issues that go to the safeguarding piece of the mandate. Supreme Court said, enter all necessary orders to safeguard the rights. We asked the court to have a hearing on apportionment of the rights because it was shown that the original VAR strip parcels, 170 of those, 170 parcels with 170 owners. Through the process, we learned that those parcels were subdivided into over 6,000 different parcels. So we said we have to apportion that. That's going to be an unreasonable burden on the ranch to have 6,000 people with household use, as opposed to how this prescriptive easement was established by the use of 170. The court totally denied us a hearing. It didn't make any evidentiary findings. It just said, well, it would be impossible. Given the large number of people that we have, this would just be impossible. So we're not going to apportion the rights. That is an error. And this needs to be, in our mind, remanded so that we can go back and we can have a hearing on apportionment. I'd like to reserve the remainder of my time for rebuttal.
Very good. Thank you, counsel. For the
With the court's permission, I'm going to
swap out maps, certainly.
stole all my court counsel's copies. Letter side version.
His approach.
Thank you.
May it please the court, my name is Aaron Boucher, bar number 38675, and I'm here to speak today on behalf of the plaintiff landowners of Castilla County, many of whom you see in the courtroom here today. I'd first like to thank the court for allowing the parties additional time to argue this matter. This is an important case and a historic case, and the people of Castilla County rely on these rights to support their livelihood.
Well,
The use-
let me stop you right there. Certainly, firewood as a source of home heating is much less common today than it was in the 1860s.
Not in the valley.
Really, I mean, is there any evidence in the record of how many, what percentage of the residences have firewood as the primary source of home heating as opposed to propane, for example?
I don't believe there's evidence in the record on that point.
Is there any evidence in the record of the extent to which residents of the valley harvest timber for construction purposes as opposed to buying it at Home Depot?
Just evidence that you see when you drive in the valley.
Log homes, for example?
And, what would you call them? Willow fences, things like that.
Okay. Why wouldn't it be appropriate to have an evidentiary hearing to develop questions such as I tried to ask and then make a decision on apportionment based on factual findings from such a hearing?
Well, because that process, doing it that way really flips the issue on its head. Because this was what Judge Perricone said specifically in response to the ranch owner's motion to carry out this extensive apportionment and dictate class-wide what people's rights were limited to in a very specific way. And Judge Perricone said, quote, "The Supreme Court charged this court with the responsibility of identifying present property owners who have rights of access to the Taylor Ranch. The court is an agency of reaction, not an agency of proaction, and thus cannot rule on evidence that is conjecture, the basis of which has not yet occurred." He then clarified that the law provides methods by which defendant can seek relief, such as actions for trespass, waste, and injunction, to mention only a few. In other words, what the court said is, as an evidentiary matter, the ranch owner had failed to raise an actual controversy. There wasn't evidence that people were exercising their rights in an unreasonable manner so as to justify class-wide limitations on their use rights.
Wasn't there some evidence in the record? I know a lot of it could be characterized as sort of conjecture based on the capacity of the lands and the number of owners that had access. But wasn't there at least some evidence about certain landowners having in excess of 20 cattle grazing, which would be an indicator that there were actual uses in excess of household use?
Well, I mean, the amount of cattle, my recollection of what was submitted to the record, was divided amongst several families all having the same surname. So it's not like it was just one household.
Oh,
And so
that wasn't clear to me from
So
from the
there are
record.
many. The surname is Lobato, which is the
we're familiar
title
with
of
that
this
name.
case, but it's a very common name down in the San Luis Valley. So the primary complaints, frankly, of the ranch owner at the time were that people who didn't have access rights were going up onto the ranch and using the resources. But putting limitations on people who have access rights because of unauthorized users doesn't solve the problem. It doesn't even go to the same issue. And so that was why the court said, if you have a problem with an access holder or anyone else taking resources from the mountain, either in the case of an access holder in an unreasonable amount or at all from an unauthorized user, then you have right of claim here, and you can bring that claim. But it doesn't fit within the context of this remand mandate. That's a separate claim. My job is to identify landowners who have land with access rights and enter orders to protect them.
And all necessary orders. So, I mean, to the extent that there's a demonstrated concern about depletion or waste, do you think that it was beyond the reach of the court in the mandate to do this, or just an insufficient showing was made that it was necessary for the court to do it?
I think the latter.
Okay.
And it could have, in its discretion, entertained that, that issue if a showing had been made. But the fact is, it wasn't made, and the court properly exercised its discretion to reject it. In the context of that argument, this apportionment argument, one thing I want to note is the ranch owner repeatedly talks about 170 original owners of property, which is not entirely accurate. What the 170 original owners are, my understanding is that's the original deeds that Beaubien granted, which are reflected on Map A, Book E. But as we can see by this map, that Map A, Book E was far from a complete picture of all the settled lands at the time. So saying that it was only 170 parcels at the beginning excludes huge swaths of land that everyone agrees was timely settled. And so,
But still, the larger point that it's been substantially subdivided and there are a lot more parcels that are part of the dominant estate still, that can't really be disputed, can it?
it absolutely is not disputed. It has been subdivided. But the fact also is the amount of land that was settled by 1869 was settled by 1869. It can't be expanded or contracted. It is what it is. And so to the extent the ranch owner could show that there was actual unreasonable use by landowners, then it would have a claim. But it was unable to meet that burden to sustain a claim. In the 14 years since remand, the ranch owner never filed a trespass action, never sought an injunction against anyone. So, you know, obviously it didn't think it had sufficient evidence to bring those claims, or for whatever reason chose not to bring them.
What about the landowner's argument, at least related in my mind, that if you've got a group of approximately 5,000 potential users, it's effectively opening the land to the general public, and therefore the easement falls of its own weight?
Well, there's two interesting things about that argument. The first is it was Justice Corliss's argument in Lobato 1. So that issue has already been addressed by the Supreme Court, the issue of whether this created a communal profit. The majority disagreed, obviously, with Justice Corliss on that point.
And I recognize that there's a lot of history here, and you're not responsible for but the recent chapter. Was there any indication in the briefing in Lobato 1 or Lobato 2 that the Supreme Court must have recognized that the group of users could balloon to 3,000, 4,000, 5,000?
Well, there's specific language in Lobato 2 itself. In Lobato 2, the court first states, and this is in footnote 7, after stating the standard for whether land has rights or not, the court specifically states, we recognize that this standard may be over-inclusive, but considering the grave deprivation of rights suffered by the landowners over the past 40 years, we are unwilling to create a standard which may again unlawfully deny some landowners their guaranteed access rights.
Well, I'm not sure
And
that
then-
responds to my question.
Well, but then, later in the opinion, when the court suggests to the trial court to revisit class certification, it acknowledges that there are over 31,000 potential claimants in Castilla County. So the court was fully aware of how many potential claimants there were, and that it was far in excess of, you know, just the 170 deeds on Map A.
And the 31,000 is a rough estimate of the county's population?
That
at
was the
time?
county's population around the time of Lobato 2.
Okay.
I
Thank you.
couldn't tell you what it is today. So the ranch owner raises a lot of issues in this appeal, but it's unclear just exactly what relief the ranch owner wants. The people who have access rights from Map A, everyone agrees that their land has access rights. So it's unclear if the ranch owner wants to just re-adjudicate those same rights again, using the exact same evidence. Because one of the things that the ranch owner does is conflate common evidence with these communal rights and suggests that just because every or most of the claimants can use the exact same piece of evidence to make their claim, that somehow they haven't had to make a claim. And our cross-appeal issue is really quite simple. The way that the court,
Wait, I'm so sorry. Before we get to the cross-appeal issue, could
Sure.
I ask you, one thing that I could discern that they wanted really fun was finality issues. Can you talk about that a little? Because it did seem as though the process will not achieve finality, is not designed to achieve finality, and that seems like it could be a problem.
well, and that ties in very closely with the argument that this is a traditional Rule 105 quiet title action. It certainly started out that way, but upon the issuance of Lobato II and the mandate, it really, the Supreme Court had already adjudicated what the rights were. It remanded to the trial court to say, okay, these are the rights, they run with the land, this is the land the rights apply to, figure out which land it is. And so at that point, it really became almost like a post-judgment class action of identifying class members. And just, all of the ranch owner's arguments in the case law about class certification are under Rule 23b3, but this class was certified under 23b2, so the notice and opt-out requirements that apply to a 23b3 class don't apply here. But getting back to your question, settlement in this valley didn't occur randomly. If you look at the outlined areas on this map, they all follow the watersheds. There's San Francisco Creek, Vallejos Creek, and the Culebra River, which runs over into the Rio Grande, and then Castilla Creek. And so rather than do personal service and naming of 31,000 people, just everyone in the county, it makes sense to focus on the areas everyone knows was timely settled. If after that process is done, and we submit that the way to do that is just the way Map A was identified, because right now, there is land within those stipulated areas that has not been adjudicated to have rights yet, because for whatever reason, the landowner didn't come forward. But that right isn't a personal right of theirs, it belongs to the land. And you can be adjudicated without exclusion or negative impact to the other right holders, because those rights have existed for centuries, or over a century. And so once that process is complete, and it could be as simple as just overlaying assessor's maps and figuring out that way who the current owner of each property is, then if the ranch wants to send notice to the remainder to get its Rule 105 finality, then that's fine, because at that point, you'll have identified at least what we think is likely to be all of the timely settled property. And so the likelihood that people outside of those areas are going to come forward, let alone successfully, to establish claims, I think would not create the morass that would be created if everyone, including the people in those stipulated areas, was named and served.
Is the blue outline in what you handed up here, is that the totality of the stipulated settlement area?
That is the total stipulated settlement area. The stipulation itself, it doesn't preclude other landowners from
No, I'm just trying to
establishing.
understand the map.
Yes.
This is the stipulated settlement.
That
area,
is a stipulated area.
And it includes map A, book E.
Yes.
Okay.
But it includes more, it includes
It's-
land beyond that.
Yeah.
Yeah, map A, book E is basically included in these long, kind of thick portions.
Mm-hmm.
And then all of these other areas, there might be part of this little peninsula that's included in map A, but like all of this land that's stipulated to along the Culebra, none of that is depicted on map A.
Okay.
The
Well,
Channel
let me-
Canyon,
Yeah, okay. Then notices were sent to 21,000 people as part of sort of the phase 2 process?
I can't state exactly how many. It was essentially the parties agreed on what constituted the north-south border of the county and sent notice to all of them.
Okay, well, that's what I was going, did the notice go to everybody in the south part of the county, or just everybody in the south part of the county who also had land within the blue outlines?
It went to everyone, I believe.
Okay.
But that notice, it wasn't service. It was a notice mailed, and it specifically said, landowners will not lose their opportunity to establish their access rights if they choose not to participate in the identification process. However, landowners who do, oh, go ahead.
I'm sorry. I think we're familiar with what that says, that it didn't extinguish their rights. Was any request made at that time, instead of sending that notice? I know that there was a request to do it by publication and then extinguish rights, but was there any request at the end to do it by service and tell people, come forward now or forever be barred?
No, the ranch owner wanted to do all of the notice by publication, and we said at that time, you can't do that. These people can be readily identified from the property tax rolls, and you can't do notice by publication.
We've been down that road
right,
before in
that's-
this litigation.
Exactly. The high court already weighed in on that one in this case. But for whatever reason, that was the position of the ranch owner. Our position, that was our secondary solution if that's the way the court wanted to go, is it could authorize service to all remaining unadjudicated people. But our position is that the much more efficient and efficacious way to do it is to identify the stipulated settled lands, because we know those people have rights. And the idea that somehow the process changes because they have to come forward and do something, well, all that does is ensure that there will be less land that is actually adjudicated. Now, that's obviously in the ranch owner's favor, but that's not what the mandate says.
But it also has the benefit of finality. I mean, that's something that's lacking here, is getting some closure on identifying who does and doesn't have access. So do you agree that had service gone out at the end, that could have set an end date, everybody needs to come forward, and it ends it, versus leaving it open as it is now?
Well, I think, and I want to be clear about this, I think that if that's the type of finality the court wants, the way to do that is to first identify the stipulated lands and then serve the remainder.
Well, aren't the stipulated lands identified by the parties? Isn't that a matter of agreement?
Well, they're not identified in a way that can be recorded in the property records, and the current owners of the property aren't all identified. In other words, we can't just take this map and record it in the property records and people can point to it and say, see, my property has access rights. There has to
Why
be some
not?
sort of description of these properties so that people can so we can determine with some degree of certainty whether property is or isn't in that stipulated area.
It's the overlay that Mr. Fannon's talking about, is that
Well,
what you're
an
talking about,
overlay,
that has to be done, that the process that the title company did for map A, book E?
well, so whether or not the title company has to do it is really a function of whether the ranch owner wants to assert res judicata. Because in order to do that, the 1960 owner of each property has to be identified. But setting that aside, The process we actually suggested was to take a GIS, a geoscience expert, to just overlay the modern assessor's maps over this map and do it that way. And because they would all have assessor's parcel numbers, all of the owners would be readily identifiable.
Aren't these meets and bounds descriptions, the blue lines?
They're not. If you look at the record, so this page, this is page 20,015 of the record. If you look at 20,017, there's a color version of this map, which is the original. This map was created by Edmund Van Diest, and he was a prolific cartographer, and he color-coded all of the uses of the property on this map. And it was based on his descriptions of that use that the parties stipulated that all of this land was settled. It was either already deeded by Beaubien, it was under cultivation, there were homes on it.
But the boundaries are not meets and bounds descriptions.
They're not. It's it would need to be overlaid with assessor's maps, or you'd have to do some sort of survey. And as we suggest in our briefs, that could be as precise or as broad as the ranch owner wants it to be, including, it could just say, you know, these sections were timely settled. Or you could do a meets and bounds description.
But there's no dispute that that's timely settled land.
There's not, and actually in the stipulation that that's attached to, paragraph 9 specifically states, CVR, which is the ranch owner, hereby waives any and all affirmative defenses to challenge the settlement of the stipulated settled lands by January 1869 in future proceedings, including on appeal. So that is established. That these lands were timely settled is established. And obviously under Lobato 2, that means they have access rights subject to a possible res judicata bar for some.
Okay, so then can I ask a follow-up to that? So earlier, Judge Welling said, well, I see a reason why you would employ two different processes. Do you agree or disagree with that?
I disagree. Well, if you're talking about the Map A process versus what was done afterwards, I do disagree, because what happened was in 2009, when the Map A process was winding down, Judge Perricone and the parties, frankly, were searching for a way to complete the remainder of the county. This map wasn't found yet. And so at that point, Judge Perricone indicated essentially that there would have to be some other evidence of timely settlement. In the meantime, the Map A process continued, and in it completed in 2012. In 2013, the parties agreed on a stipulated map prior to this one, and the plaintiffs at that time encouraged the court to go back to the Map A process, do the same process for this stipulated map. But Judge Plotz at that time felt that he was bound by Judge Perricone's, what he perceived to be a change in direction. And that's why he didn't ever go back to the geographic kind of class-based process. And you know, doing the process that way is really the only reason there was a benefit to certifying a class. You know, the class was defined as current landowners in Castilla County whose property was settled at or before the time of William Gilpin's ownership of the Taylor Ranch property, but excluding any such owners who, while owning the land on which they now base their claims, were personally named and served in both the 1960 Torrens action and the 1960 Salazar Quiet Title action, or whose 1960 predecessors in title were personally named and served in both earlier actions. And that's in the motion for class cert. That's at 7796 of the record. And then the order certifying the class, which was requested to be a 23B2 class, is at 8464. And for all the ranch owners' complaints about class certification, I would note as well that they could have appealed that class certification order, but they didn't.
That's not preclusive, though, is it?
It's not, but It's certainly not a waiver in the way that they've waived other issues on this appeal.
Can I, as you're kind of changing gears, why was the trial court so jealously protective of granting access to the title examiners?
Well, the title examiner was a court-appointed expert.
706?
Well, I don't know that the court ever invoked that rule.
I was kind of but it looks, and I mean, it kind of quacks like a duck, walks
Right.
like a duck.
I mean, for intents and purposes, you know, I think the way that Judge Perricone characterized them was as an official court advisor. But when these title reports would come out, all of the documentation supporting the title company's conclusions about who owned the land, that was all made available to the parties. So the idea that all of this was done in secrecy and all anyone saw was the bottom line, that's not really accurate. Their report included an entire chain of title. It included basically all of the evidence that they had to show that the current owner of, you know, this parcel property is, you know, Joe Smith. And same with the 1960 owner, the chain of title was included. And
During the proceedings, did the ranch owner ever call to the court's attention any specific errors in these title company reports?
quite the contrary. The ranch owner actually conceded that there was nothing to indicate there was any inaccuracy in the reports, and that was at 8971 of the record.
Wasn't there some allusion to the fact that they may come forward with evidence at some point based on a 1913 survey, or am I misremembering?
They could have, but I mean, that's all moot. They stipulated. So whatever that 1913 map, which I've never seen, says is really irrelevant.
Because it goes to what was timely settled as opposed to who currently owns.
Precisely. Yeah, I mean, obviously a 1913 map could only be helpful to determine historical settlement. I don't know that it would be helpful to determine how it could be helpful to determine current ownership. But the ranch owner never raised any issues about the accuracy of the title company's reports, and has never, in the entire remand process, ever even argued that a single person was granted access rights outside of map A or outside of this map. So it's unclear what their complaint really is. I mean, they're complaining about process, but I mean, the process is done. People have rights.
If we think that the court's guardrails that it put around access to the title company is what was a bridge too far, are you saying that it would be subject to a harmless error analysis as to you know, no meaningful impact, given that there's nothing to actually dispute any of their work?
Well, the way I would characterize it is there was nothing at any time stopping the ranch owner from hiring its own title expert to evaluate the sufficiency of the court's appointed title expert, to determine whether there were problems with it, to designate them as an expert, to put a motion or to put them on the stand to say, no, the title company did this wrong. This person isn't accurately identified.
But 706 also contemplates that there's some discovery of the court's expert.
Well, and then I go back to the fact that these reports all had the title work included in it. They were attached, and each time the title company, now this all occurred before my tenure on this case, but my understanding is that when the title reports would issue, not only were the backing documents included, but the title company would come to the courtroom, there would be a hearing or a status conference, and they would be there to answer the parties' questions if they had any about the report. I don't believe that happened on the record, but it was, it certainly would have facilitated if the ranch owner had a bona fide dispute about the accuracy of the title company's work. it could have, it would have given them enough to go forward and press that issue. But they never did. They just complained about the process.
Your time is winding down if you want to make your closing pitch.
I really think this case is quite simply resolved, Your Honor. All the trial court needs to do is finish what it started with map A on this map. And if the ranch owner wants finality, it can serve everyone else once that's complete.
Very good. Thank you, counsel. We have a little bit over 4 minutes.
Thank you, Your Honor. I'd like to take up the last issue first, but not spend too much time on it because I have limited time and a few issues to cover. Indeed, the title company was treated as an expert, and with all due respect to Mr. Boucher, we were not given access to their work product. They brought some things, mostly they would bring map A, book E, and they would draw and say, this is the area that we're reporting on. We did not get chains of title. We did not see all of their maps. Some of their maps they deemed proprietary. They weren't public. So what this amounted to was us getting an expert report that had conclusions only. We were not allowed to examine the expert and to say, well, go out and get your own expert to refute that. Puts the burden of proof on us. That's inappropriate.
Where's the offer of proof in the record that that was prejudicial to you?
There are multiple instances where we challenged the conclusions of the title company when we filed our objections to proposed orders granting access rights to the people shown on the reports. One specific reference I talked about in my prior dissertation in the record at 9510 to 9512. With the title company claiming, in essence, that they couldn't really say if these 1913 numbers matched up with map A, book E. We wanted to challenge that, and we weren't allowed to. There are numerous instances like that. I'd like to touch on the issue of service by publication, mischaracterized. If you read our brief, all we were talking about for service by publication were unknown parties. The plaintiffs themselves in this quiet title action appropriately named as a category of defendants unknown parties who may claim an interest in the property at issue. That's what you do under Rule 10A. That's what you do in a Rule 105 action. Everybody had been identified. Everybody who purported to own map A, book E property was identified. Everybody in the southern half was identified and notified. We were at the end of that process, and we said, court, to achieve finality, we need to serve, as you always do in a Rule 105 action, unknown people.
But actually, to achieve finality, didn't you also need to serve the people who hadn't come forward? Because the publication, the notice that they were sent explicitly said, you don't need to worry about it. If you don't come forward, it doesn't affect your rights.
And we had advocated from the outset of the remand to do that. We were denied that.
Did you ask for it at the end?
We asked that the notice that the court mailed, that the court said would serve due process, we asked that that notice say you either come forward or you are barred, and the court denied us on that and said that no, we are not going to bar anybody. We're just going to tell them they have the right to opt in. So
Did you ask to personally serve that notice?
Not at that second time, because the court had decided that mailing notice, and specifically said mailing notice is sufficient for due process under Mullane versus Central Hanover Bank, that mailing was sufficient for due process, and we even submitted a notice form that said, you will be barred if you do not respond by a date certain, and the court rejected that.
But never asked to serve that?
We did not ask at that second point to serve them, no we didn't. But we were only seeking notice, service by publication on unknown parties, not those who had an identifiable interest, who had been identified. I'm not the smartest guy in the world, but I can read Lobato 1 and Lobato 2. I know service by publication on people with an identifiable interest was not going to be sufficient. We were just saying on the class of unknown people. My final point on Justice Corliss's holding with respect to communal rights, yes, that's what Justice Corliss said. The Supreme Court, though, while not in disagreement with Justice Corliss, didn't want the creation of communal rights. What it wanted and it expected were landowners to come in, make a claim, establish a claim, meet a burden of proof. They were asked, the court was asked, the Supreme Court in Lobato 2 was actually asked to engage in administrative process. At 11:58, The landowners argue that access rights should not be limited to landowners able to trace settlement claims to original settlers, but contend that such rights should be available to all landowners in Costilla County, not barred by res judicata. That's a request for an administrative process. Don't make anybody meet a burden of proof. The answer, we disagree.
Very good.
Thank you for your time.
Thank you, counsel. I want to thank counsel on both sides for their excellent briefing, as well as their arguments today. I know behind each of the lawyers that were arguing on both sides, there's quite a few lawyers who have spent a considerable portion of their career on this case, and we understand, as is evident from the audience both today and in an overflow room, of the public importance of this case. But we appreciate everybody's work on this. Your excellent work makes our decision in one respect more difficult, but easier at the same time that it has been so well presented to us. So thank you very much for your work. The case will stand as submitted, and a written ruling will issue in due course. That ends our morning docket, so we will be in recess if the bailiff would so announce.